Imagine waking up one morning, walking down to your dock with your coffee in hand, ready to spend the day on the water in the boat you worked years to pay off, the boat that's legally yours, the title with your name on it, sitting safely in your filing cabinet. But when you get to the dock, there's nothing there, just empty water where your $50,000 investment used to be. No note, no warning, no explanation. Your boat has vanished into thin air. You call the police frantic, thinking you've been the victim of some elaborate theft ring. But what the officer tells you stops your heart cold. Your boat wasn't stolen by criminals. It was taken by your bank. The same bank you paid off 3 years ago. The same bank that sent you a congratulatory letter when you made that final payment. And here's the truly terrifying part. What they did is completely legal. They're using technology so advanced, so precise and so quietly deployed that thousands of boat owners across America have no idea they're being targeted right now, at this very moment, as you're watching this. The system tracking them is already active. The drones have already photographed their vessels. The artificial intelligence has already flagged their accounts. And the repossession order has already been generated. They just don't know it yet. What I'm about to reveal to you in the next several minutes will fundamentally change how you think about property ownership, financial institutions, and the technology that's been deployed against everyday Americans without their knowledge or consent. The information you're about to hear has been deliberately kept out of mainstream media coverage. It's been buried in technical journals, hidden in legal filings, and obscured behind banking industry jargon that's designed to confuse rather than clarify. But I've spent months investigating this, talking to victims, interviewing lawyers, examining court documents, and speaking with former bank employees who've blown the whistle on these practices. And what I've discovered is so disturbing, so fundamentally wrong, that it demands to be exposed to the light of day. Before we go any further, I need you to understand something crucial. This isn't some conspiracy theory. This isn't speculation or fear-mongering. Every single fact I'm about to share with you is documented, verifiable, and happening right now in marinas from Florida to California, from Texas to Washington State. Real people are losing real property that they legitimately own, and the legal system is allowing it to happen because of loopholes so obscure that most attorneys don't even know they exist. These aren't people who defaulted on loans. These aren't people who broke the law or failed to meet their obligations. These are responsible boat owners who did everything right, and they're still losing everything. If you own a boat, if you've ever financed a boat, or if you're planning to buy a boat in the future, what you're about to learn could save you from financial devastation. And even if you don't own a boat, you need to understand this because the same technology and the same legal frameworks are being applied to cars, RVs, homes, and virtually any asset that can be financed through a major financial institution. The banks don't want you to know what I'm about to tell you. The technology companies providing these systems have non-disclosure agreements with their clients specifically to prevent this information from becoming public knowledge. The law firms defending these practices in court use procedural tactics to keep cases out of the spotlight and away from jury trials where public sympathy might turn against them. But the truth has a way of emerging, and today, that truth is going to be laid bare in front of you with such clarity that you'll never look at your financial relationships the same way again. I'm going to show you exactly how this system works, who's profiting from it, why it's legal, and most importantly, what you can do to protect yourself before it's too late. But I'm warning you right now, some of what you're about to hear will make you angry. It should make you angry. Because what's happening represents one of the most egregious abuses of technological power and legal technicalities in modern American history. Now here's where things get really interesting, and this is the part that nobody's talking about publicly. The system I'm describing isn't just some theoretical framework or isolated incident. It's a fully operational nationwide network that's been deployed by multiple major financial institutions, and it's generating millions of dollars in revenue through a process that most people would consider theft if they truly understood how it worked. But these banks have found a way to make it legal. Not ethical, not fair, not just, but legal. And that distinction is everything in a courtroom. They've identified a vulnerability in how boat financing is structured, a loophole in maritime law, and a gap in consumer protection regulations that's so specific and so technical that it's essentially invisible to anyone who isn't a specialist in this exact intersection of law, technology, and finance. Then they've automated the exploitation of this vulnerability using cutting-edge technology that can identify targets, assess value, track locations, and execute repossessions with minimal human oversight and maximum efficiency. The technology stack they're using is genuinely impressive from an engineering standpoint, even as it's morally reprehensible in its application. We're talking about commercial drone surveillance with high-resolution cameras capable of reading hull identification numbers from hundreds of feet in the air. We're talking about artificial intelligence algorithms that can analyze thousands of financial records, cross-reference them with public databases, identify discrepancies in documentation, and automatically generate legal filings without a human ever reviewing the case. We're talking about geolocation tracking that monitors when boats are moved between states, triggering automatic updates to legal jurisdiction claims. We're talking about automated valuation models that assess current market value in real time to determine whether a repossession action will be profitable before it's even initiated. This isn't some guy with a clipboard walking down a dock. This is a sophisticated technological operation that would make most tech startups jealous of its efficiency and scale. But here's what makes this entire system so insidious, and this is the part you absolutely need to understand before we go any deeper. The legal basis for these repossessions doesn't come from a boat owner defaulting on payments or violating loan terms in any traditional sense. It comes from something far more subtle and far more difficult to defend against. It comes from documentation errors, technical violations of maritime recording requirements, and creative reinterpretations of security interest clauses that were originally written decades ago for completely different purposes. In many cases, the boat owner has done absolutely nothing wrong in any meaningful sense. They made every payment on time, they maintained the vessel properly, they kept their insurance current, they followed every rule they knew existed, but somewhere in the chain of paperwork, somewhere in the filing of documents with the Coast Guard or state agencies, somewhere in the transfer of the loan between financial institutions, a technical error occurred. Maybe a form wasn't filed within the required time frame. Maybe a lien wasn't properly recorded in a specific jurisdiction. Maybe the language in the security agreement was interpreted differently than the borrower understood it. And that technical error, that minor paperwork discrepancy, becomes the legal basis for the bank to claim that they still have a valid security interest in a boat that was supposedly paid off years ago. Now you might be thinking, surely there are consumer protection laws that prevent this kind of abuse. Surely there are regulations that require banks to notify owners before taking their property. Surely there's some kind of due process that gives people a chance to contest these actions in court before their assets disappear. And you'd be right to think that, because in almost every other area of consumer finance, those protections do exist. But boats occupy this weird liminal space in American law. They're not quite real property like a house. They're not quite personal property like a car. They're vessels, governed by a complex mix of federal maritime law, state UCC provisions, Coast Guard regulations, and common law principles that date back centuries. And in that complexity, in that confusion of overlapping jurisdictions and conflicting statutes, the banks have found their opportunity. They've found the cracks in the system where consumer protections don't quite reach, where notification requirements don't quite apply, where the normal safeguards that would stop this kind of action in any other context simply don't exist. Let me give you a specific example of how this works in practice, because the details here are absolutely crucial to understanding why this is so difficult for victims to fight. Let's say you bought a boat 10 years ago for $80,000. You financed it through a major bank, made every single payment on time for 7 years, and paid it off completely. The bank sent you a satisfaction of lien letter. You received your title. As far as you're concerned, and as far as any reasonable person would understand the situation, you own that boat free and clear. But here's what you don't know. When you originally financed that boat, the bank filed what's called a preferred ship mortgage with the Coast Guard. This is a federal filing that gives them priority claim on the vessel. Now, when you paid off the loan, the bank was supposed to file a separate document releasing that mortgage. But here's where it gets interesting. There's no automatic mechanism that forces them to do this. There's no penalty for failing to file the release. There's no government agency that audits these filings to make sure they're current. So in many cases, deliberately or through negligence, The release never gets filed. The preferred ship mortgage remains on the Coast Guard records, even though the underlying debt has been satisfied. Fast forward 3 years, you're enjoying your paid-off boat. You've forgotten all about the financing because it's been over and done with for years. But the bank hasn't forgotten. They've deployed their AI system to analyze their old loan portfolios, cross-referencing them with current Coast Guard records and market valuations. The algorithm identifies your boat. It notes that the preferred ship mortgage is still active on record. It checks current market values and determines that your boat, which you bought for $80,000, is now worth $120,000 because the marine market has been hot. The AI calculates that even after repossession costs, auction fees, and legal expenses, there's significant profit potential. So it generates a case file, automatically drafts legal documents claiming that you're in violation of the security agreement because of some technical requirement you didn't even know existed, and initiates a repossession order. All of this happens without a single human at the bank reviewing your actual payment history, or considering that you satisfied the debt years ago. Now here's where the drone surveillance comes in, and this is where the technology becomes truly Orwellian. The bank contracts with a specialized asset recovery firm that uses commercial drones equipped with sophisticated cameras. These drones conduct systematic flights over marinas, lakes, rivers, and coastal areas, photographing thousands of boats in a single day. The images are fed into facial recognition-style software that's been adapted for hull identification numbers. The system can read those tiny registration numbers on the side of your boat from hundreds of feet away, even in less than perfect lighting conditions. Once they've located your specific vessel, they begin regular monitoring. The drones come back weekly, or even daily, documenting whether the boat is present, whether it appears to be in use, and most importantly, whether there are patterns to when you're away from the vessel. They're building a behavioral profile, identifying the optimal time to execute the repossession with minimal confrontation or resistance. And all of this surveillance is happening without your knowledge, without your consent, and completely legally, because the airspace above navigable waters is public domain, and there are no restrictions on photographing boats in public view. When the repossession team finally moves in, they do it with surgical precision. They choose a time when their surveillance data indicates you're unlikely to be present. They arrive with proper documentation that, on its face, appears to give them legal authority to take the vessel. In most cases, marina operators or dockmasters don't question them because they have official-looking paperwork. They're professional in their demeanor, and they claim to be acting on behalf of a major financial institution. The boat is removed from its slip, loaded onto a trailer, or piloted away by a professional captain, and disappears into the bank's asset recovery network before you even know it's gone. By the time you discover the theft and start making phone calls, your boat has already been moved to a secure facility, often in a different state, specifically chosen because the jurisdiction there is more favorable to the bank's legal position. And here's the truly devastating part. Even though you know this is wrong, even though you have documentation proving you paid off the loan, even though this seems like the most clear-cut case of wrongful repossession imaginable, getting your boat back is going to cost you tens of thousands of dollars in legal fees and could take years of litigation. Because here's how the legal game works, and this is the part that makes victims feel completely helpless. Once the bank has physical possession of your boat, the burden shifts to you to prove why they shouldn't have it. You become the plaintiff in a legal action trying to recover your own property. The bank, with its team of specialized maritime lawyers, will file motion after motion challenging jurisdiction, arguing technical points about documentation, and burying you in legal complexity. They know that most boat owners don't have the resources for a prolonged legal battle. They know that the cost of litigating these cases often exceeds the value of the boat itself, especially once you factor in storage fees that are accruing daily while your boat sits in their impound facility. They're counting on you to give up, to accept a settlement where you walk away with a fraction of what your boat is worth, or better yet, from their perspective, to simply abandon the fight altogether so they can sell the vessel at auction and pocket the proceeds. Now let me tell you about the AI component of this system, because this is where it becomes clear that we're not talking about isolated incidents or random errors. We're talking about a systematized, industrialized process for extracting value from consumers through legal technicalities. The artificial intelligence platforms these banks are using were specifically designed for this purpose. They're not general-purpose AI systems that happen to be applied to boat repossession. They're custom-built tools created by legal tech companies that specialize in asset recovery. These systems can process millions of loan records in hours, identifying potential targets based on dozens of criteria. They look for loans that were originated during specific time periods when documentation standards were lax. They identify cases where loans were sold between institutions multiple times, creating opportunities for recording errors. They flag borrowers who moved between states after purchasing their vessels, creating jurisdictional complications. They even analyze social media and online listings to verify current location and condition of vessels, building comprehensive profiles that would take human investigators months to compile. The really disturbing innovation here is that these AI systems don't just identify opportunities for repossession. They actually calculate the probability of successful legal defense by the borrower. They analyze factors like the borrower's financial resources based on credit reports and property records, estimating whether they're likely to hire an attorney and mount a serious defense. They assess the complexity of the legal issues involved, rating cases based on how difficult it would be for a borrower to prove their position. They even factor in the jurisdiction where the case would likely be litigated, because some courts and some judges are statistically more favorable to financial institutions than others. Then the AI generates a score, essentially a profitability index, that weighs the expected value of the recovered asset against the costs and risks of legal challenge. Only the highest scoring cases, the ones where the math works overwhelmingly in the bank's favor, actually proceed to repossession. This means the system is specifically designed to target the most vulnerable victims, the ones least able to defend themselves, while avoiding cases where the borrower might have the resources and legal sophistication to fight back effectively. Let's talk about the human cost of this system, because beyond the legal technicalities and the impressive technology, real people are being devastated by these practices. I've spoken with boat owners who've lost vessels that represented their retirement dreams, boats they planned to live on after selling their homes and downsizing. I've talked to small business owners who use their boats for charter fishing or tourist excursions, losing not just the vessel, but their entire livelihood in a single day. I've interviewed families who saved for decades to buy their boat, making sacrifices and working extra jobs to afford something they could enjoy together, only to have it ripped away based on paperwork errors they had no way of knowing existed. These aren't wealthy people with multiple toys sitting around. These are middle-class Americans for whom their boat represents one of their most significant assets, often their second most valuable possession after their home. And when that asset is suddenly gone, seized by a bank they thought they had no relationship with anymore, the psychological and financial trauma is immense. What makes this even worse is the shame and isolation victims feel. When your boat gets repossessed, you don't want to talk about it. You feel like you must have done something wrong, even though you know you didn't. You feel embarrassed, like you failed somehow, even though you were the victim of a predatory system. The banks count on this shame to keep victims quiet. They count on people not wanting to admit what happened, not wanting to explain to their friends at the marina why their slip is suddenly empty, not wanting to face the judgment of people who assume they must have defaulted on payments or gotten in over their heads financially. This isolation prevents victims from finding each other, from realizing this is a pattern rather than an individual mistake, and from organizing any kind of collective response or class action that might actually force systemic change. Now I need to tell you about the scope of this problem, because it's far larger than anyone outside the banking industry realizes. Based on my investigation and conversations with industry insiders, I believe we're talking about thousands of boats being targeted annually through these AI-driven repossession programs. The exact number is impossible to determine because there's no central reporting requirement and banks have zero incentive to publicize these numbers. But if you look at court filings, arbitration records, and complaints filed with state attorneys' general offices, a pattern emerges. The volume of these cases has been increasing exponentially since 2020, right around the time when the AI and drone technologies became sophisticated enough and cheap enough to deploy at scale. What was once a labor-intensive process requiring investigators to physically locate vessels and lawyers to manually review files has become an automated pipeline that can process hundreds of cases simultaneously with minimal human oversight. The financial incentive for banks to pursue this is enormous, and this is the part that really illuminates why this problem isn't going away on its own. When a bank repossesses a boat that's actually been paid off, they're not just recovering an asset to satisfy a legitimate debt. They're seizing an asset they have no valid claim to and converting it to cash through auction or private sale. This is essentially pure profit minus their operational costs. And because they've used AI to select only the cases where legal challenge is unlikely or where they have technical documentation advantages, their success rate is extremely high. Industry insiders I've spoken with estimate these programs are generating profit margins exceeding 70%, which is virtually unheard of in traditional banking operations. For context, most consumer lending products generate profit margins in the single digits after accounting for default risk and operational costs. This is a goldmine for financial institutions looking to boost quarterly earnings, and the incentive to expand rather than curtail these programs is overwhelming. Here's something else that's going to blow your mind. Some banks are actually selling their technical documentation errors as assets to specialized investment firms. Think about that for a second. They're packaging up loan files where they know there are recording errors, lien release failures, or documentation discrepancies, and they're selling those files to companies that exist solely to exploit those errors for profit. These aren't traditional debt buyers purchasing defaulted loans at a discount. These are vulture firms buying performing loans that were completely paid off, specifically because the documentation problems create legal leverage for extracting additional value from the borrower or seizing the collateral outright. This has created an entire secondary market in what I can only describe as weaponized paperwork errors. And because these transactions happen between financial institutions under non-disclosure agreements, there's no public visibility into how large this market has become or how many boat owners are potentially affected. The legal framework that allows this to happen is Byzantine in its complexity, but I'm going to try to break it down in terms anyone can understand. Boats financed in the United States can be secured under either state law through the Uniform Commercial Code or under federal law through the Ship Mortgage Act. The Ship Mortgage Act, which dates back to 1920, was originally designed to facilitate commercial shipping by creating a federal registry for vessel liens, similar to what exists in most other maritime nations. But it's been expanded over the decades to cover recreational vessels above certain sizes, generally boats over 5 net tons, which includes most cabin cruisers and sailboats. When a bank takes a preferred ship mortgage under federal law, they get certain advantages that don't exist under state UCC filings. Most significantly, they get nationwide priority that supersedes later liens and survives transfers between states. But the flip side is that these mortgages are supposed to be strictly regulated, with specific requirements for filing, disclosure, and release. Here's where the banks have found their loophole. The regulations around releasing a preferred ship mortgage are surprisingly vague about timeframes and enforcement. While the law clearly states that a mortgage should be released when the debt is satisfied, there's no specified deadline for filing that release and no penalty structure for failing to do so. Additionally, the burden of ensuring the release gets filed isn't clearly assigned. Some interpretations suggest it's the lender's responsibility. Others argue the borrower should request and verify the release. And still others claim it's the Coast Guard's job to maintain accurate records. In this ambiguity, banks have found opportunity. They can argue in court that they never explicitly released their security interest, that the borrower's payment of the loan doesn't automatically extinguish the mortgage under federal law, and that various technical requirements of the security agreement weren't satisfied even though the financial obligation was met. To a non-specialist, these arguments sound absurd. But in front of a judge who's applying strict interpretation of maritime law statutes, they can actually prevail, especially when the boat owner can't afford sophisticated legal representation to counter these technical arguments. Let me tell you exactly what you need to do to protect yourself, because awareness of this problem is only useful if it translates into action. First and most importantly, if you've ever financed a boat, you need to verify that all security interests have been properly released and recorded. Don't just assume that because you received a satisfaction letter from the bank, everything is handled. You need to personally check the Coast Guard's National Vessel Documentation Center database if your boat is federally documented, or your state's UCC filing system if it's state registered. Search for your vessel by documentation number or hull ID and verify that no active liens or mortgages appear. If you find that a lien is still showing as active, even though you paid off the loan, you need to address this immediately. Contact the lender in writing, send the communication via certified mail with return receipt, and explicitly demand that they file the proper release documentation. Keep copies of everything, including your original loan documents, payment records, and the satisfaction letter they sent you. Second, if you're currently financing a boat or planning to buy one, you need to understand exactly what type of security interest the lender is taking and what your obligations are beyond just making payments. Insist on clear written explanation of what steps must be taken to fully release the security interest when the loan is paid off. Include specific language in your loan documents requiring the lender to file all necessary releases within 30 days of final payment and providing penalties if they fail to do so. Most banks will resist this kind of specific contractual language, which should tell you everything you need to know about their intentions. If a lender won't agree to clear terms for releasing their security interest, consider that a massive red flag and finance through someone else. Third, document everything about your boat and your ownership. Take detailed photographs of your vessel, including clear shots of the hull identification number. Keep your title, registration, and all loan documents in a secure location, preferably with copies stored digitally in multiple places. Create a file that includes the contact information for your lender, your loan number, dates of all payments, and any correspondence you've had about the loan. If your boat ever disappears and you need to prove wrongful repossession, this documentation will be crucial. The more evidence you have readily available, the harder it will be for the bank to drag out the legal process and the more likely you are to prevail quickly. Fourth, consider getting a maritime attorney to review your situation if you have any concerns about your documentation, or if you've received any unusual communications from banks regarding boats you paid off years ago. Yes, this will cost you some money up front, but it's far cheaper than trying to recover your boat after it's been wrongfully seized. A good maritime attorney can audit your documentation, identify any vulnerabilities, and help you close those gaps before they become problems. They can also send formal demand letters to banks requiring them to clean up their records, which carries more weight than requests from individual borrowers. The broader implications of what I've been describing extend far beyond the marine industry. The technological and legal frameworks being deployed against boat owners are already being adapted for other asset classes. The same drone surveillance techniques are being used to locate cars, RVs, motorcycles, and even aircraft. The same AI systems that analyze boat loan files are being trained on auto loans, personal property loans, and equipment financing. The same legal strategies that exploit maritime law loopholes are being developed for UCC Article 9 complications and state property law ambiguities. If these practices aren't challenged and stopped in the marine context, they will spread throughout consumer finance until AI-driven technical repossession becomes the norm rather than the exception. We're looking at a future where any financed asset could potentially be seized years after you paid it off, based on documentation technicalities you had no way of knowing existed, using surveillance technology you had no way of detecting, all completely legally under current law. This is why exposure matters. This is why sharing information about these practices is crucial. Banks rely on operating in the shadows, using legal complexity and technological sophistication as shields against public scrutiny. When these practices are exposed to sunlight, when enough people understand what's happening and demand change, the political and legal landscape shifts, Regulators start asking questions, legislators start drafting bills, judges start viewing these cases with appropriate skepticism rather than deference to financial institutions. But that process only begins when people like you understand what's happening and refuse to accept it as inevitable or legitimate just because it's technically legal under current law. What we're witnessing is a fundamental breakdown in the social contract between financial institutions and the public they ostensibly serve. Banks are supposed to facilitate economic activity, help people achieve their goals, and operate within both the letter and the spirit of the law. Instead, they're deploying military-grade surveillance technology and predatory legal strategies against their own customers, people who fulfilled their obligations and played by the rules, extracting profit from technical violations that create no actual harm or risk to the institution. This isn't banking, it's sophisticated theft, dressed up in legal language and enabled by technological systems that most people don't understand and couldn't defend against, even if they wanted to. The power imbalance between individual consumers and major financial institutions has always been significant, but with AI and drones now in play, that imbalance has become a chasm that swallows people whole with no accountability and no recourse. I want to be absolutely clear about something. I'm not anti-bank and I'm not anti-technology. Legitimate asset recovery, when someone actually defaults on their obligations, is a necessary part of the lending ecosystem. And technology that makes business processes more efficient generally benefits everyone. But what I've described here isn't legitimate recovery, and it isn't efficiency. It's the systematic exploitation of vulnerable people using technical advantages they can't match, and legal complexities they can't navigate. It's wrong, and it needs to stop. The question is whether enough people will understand what's happening and demand change before these practices become so entrenched that they're impossible to dislodge. The banks engaging in these practices are counting on your ignorance, your shame, your financial limitations, and your isolation. They're counting on you not understanding maritime law, not being able to afford proper legal representation, not having access to the documentation you'd need to prove your case, and not connecting with other victims who could corroborate that this is a pattern rather than individual errors. Every single one of those assumptions can be challenged. You can educate yourself about your rights and the technical requirements of your loan documentation. You can document everything and maintain meticulous records that prove your position. You can seek out competent legal help. Many maritime attorneys will take wrongful repossession cases on contingency if the facts are strong. And you can share your story, connect with other victims, and build the collective voice that forces change through public pressure, even when individual legal challenges fall short. Everything I've told you today is documented and verifiable. This isn't speculation or theory. It's happening right now to real people, and the scale is growing as the technology becomes more sophisticated and the legal strategies become more refined. If you own a boat, if you've ever financed a boat, or if you know someone who owns a boat, they need to hear this information. Share it widely, discuss it openly, and don't let the banks count on silence and complexity to shield these practices from scrutiny. The only way this changes is if enough people understand what's happening and collectively demand that lawmakers close these loopholes, that regulators enforce proper oversight, and that courts view these technical arguments with the skepticism they deserve. Your boat isn't just property, it's freedom, it's recreation, it's investment, and for many people it's a piece of their identity and their dreams. The fact that it can be taken away based on paperwork technicalities years after you paid it off, using surveillance technology that feels like something out of a dystopian novel, should outrage everyone regardless of whether they own a boat or not. Because today it's boats, tomorrow it's cars, and next week it's your home. The mechanisms being built and refined right now will eventually touch every aspect of personal property and consumer finance. Unless we collectively decide that technical legality isn't sufficient justification for practices that violate every reasonable person's understanding of fairness and property rights.